My name is Anjali Sharon, and I'm the Associate Director of Asia Society Southern California. On behalf of ASSC, it is my pleasure to welcome you to our program entitled U.S. Bans on TikTok and Wechat, Legal and Policy Issues. We are fortunate to have three internationally renowned experts who will examine the Trump administration's executive orders as they relate to national security, constitutional law, and U.S.-China relations. The conversation will be moderated by ASSC Advisory Board Member, Dr. Siegel Song, and we are delighted to be joined by over 1,000 attendees tuning in from 29 countries from all over the world. It is my privilege now to turn it over to Siegel, who will introduce the panelists and begin the discussion.
Thank you, Angelia. Good afternoon, everyone. Good evenings for those joining from the East Coast, and good mornings to our friends calling from Asia. I am Siegel Song, Advisory Board Member from Asia Society, Southern California. Today, we're hosting a webinar program about U.S. bans on TikTok and Wechat, legal and policy issues. We're very excited to have three leading experts joining us today: Dean Erwin Chemerinsky, James Dempsey, and Dr. Susan Shirk. They will discuss the President's executive orders that intended to ban TikTok and Wechat from the perspectives of constitutional law, cybersecurity and data privacy, as well as its implications to US-China relations. I think many of you have probably already heard their names or read their work, given their reputation and decades of expertise in their own fields. So let me only very briefly introduce them here, and you can find their more detailed bios from the event website. Let me start with our first speaker, James Dempsey. Jim is a leading expert on data privacy and cybersecurity for 3 decades. He's currently the executive director at Berkeley Center for Law and Technology. Between 2012 and 2017, he was appointed by President Obama to be the part-time member of Privacy and Civil Liberties Oversight Board, which is an independent federal agency charged with advising senior policymakers and also overseeing nation's counterterrorism program. Our second speaker, Erwin Chemerinsky, is a dean at UC Berkeley School of Law, which, by the way, is my own alma mater. He's also the Jesse H. Chopper Professor of Law at UC Berkeley School of Law. Dean Chemerinsky, he is author of many books, including leading case books and treatises on the subjects of constitutional law, criminal procedure, and federal jurisdiction. Now coming to our third speaker today, Dr. Susan Shirk. She is the chair of 21st Century China Center at UC San Diego. She's also the former Deputy Assistant Secretary of State during the Clinton administration. Dr. Shirk first visited China in 1971 and has been teaching, writing, researching, and engaging China diplomatically ever since. So before we start the program, let me just quickly go over some of the housekeeping rules. First of all, for those of you who need CLE credits, please find the CLE credit registration form in the Q&A box that is currently circulating at the very bottom of the screen. That form will also be circulated again at the very end of the program. Make sure that you sign it. Secondly, if you have any questions, please feel free to submit it also in the Q&A box throughout the program. We'll come to your questions at the end of the program. Now, let me give you a quick update about the history of the executive order that intended to ban Wechat and TikTok, and also what has happened ever since. On August 6, 2020, the Trump administration issued 2 executive orders that intended to ban 2 major China social apps, TikTok and Wechat, from the US market. The executive orders, which are based on national securities, prohibit any persons and any property that is subject to the US jurisdiction from carrying out any transactions with TikTok, Wechat, and their parent companies. In response, TikTok entered into a number of negotiations with American companies, including first with Microsoft, then with Oracle and Walmart, trying to spin off part of the US operations and assets. At the same time, 4 litigations have been launched challenging constitutionality of the executive orders, including 1 Wechat litigation and 3 TikTok-related litigation. The Wechat litigation was filed in the Northern District of California by a group of Wechat users living in the United States, which is known as US Wechat User Alliance. That is a nonprofit organization specifically established simply for the purpose of challenging the Wechat executive order. As to the other 3 TikTok-related litigation, that included 1 major litigation filed by TikTok and its parent company, ByteDance, in Central District of California, the second one filed by TikTok creators and users, and the third one filed by TikTok employees. Moving fast to September 18th, 2020, the Secretary of State issued identifications of prohibited transactions, trying to bring some clarity to what types of transactions are prohibited in the executive orders. Then, as of today, 2 injunctive release have been granted by the federal judges, first from the Central District of California and then from the District of Columbia regarding the Wechat and TikTok litigations. So I think that should quickly summarize what has happened and where we are now today. Now, we have prepared a list of questions surrounding executive orders to our speakers that would like to hear from you. So let me turn to our first speaker, James Dempsey. Jim, are you ready? So Jim, can you give us a quick summary of the legal work under which the authority of the president was granted under IEPA, which is International Emergency Economic Powers Act? And also, what is IEPA's limitation or restrictions? And also, we talked earlier over the phone that CFIUS review process might also play a role in this picture, especially when it comes to TikTok. Can you elaborate on that? Thank you, Jim.
Yes, Seagull, and it's a great pleasure to join you and to be part of this event hosted by the Asia Society of Southern California. So there are, as you suggested, Seagull, 2 statutes at issue here. One is the International Economic Emergency Powers Act, or IEPA, as we say, International Economic Emergency Powers Act. This was adopted in the 1970s, and it gives the president some significant powers whenever the president declares a national emergency based on a finding that there is an unusual and extraordinary threat, which has its source in whole or substantial part outside the United States, to the national security, foreign policy, or economy of the United States. And if the president declares that there is such a national emergency, he has the authority under the statute to prohibit any transaction involving any property in which any foreign country or a foreign national has any interest with respect to any property subject to the jurisdiction of the United States. So the president can ban any transaction, which is a very broad term, and property, a very broad term. And IEPA has been used by a number of presidents to impose economic-based sanctions, mainly against countries. President Obama signed an executive order in 2015 invoking IEPA to impose economic sanctions on North Korea in retaliation for a cyber attack on the Sony motion picture company. President Obama issued another order in 2016 against some Russian individuals, including senior leaders of Russia's military intelligence agency, for their work in hacking into the Democratic National Committee in 2016 and for their information operations directed at the US presidential election. Now, in 2019, President Trump issued an executive order declaring that there was an extraordinary national emergency with respect to the information and communications networks and services being offered in the United States, particularly by Chinese companies. That 2019 order didn't ban anything, it didn't sanction anything, but it set in motion a process and signaled the president's intent to look more closely at Chinese participation in US telecommunications services or any information services in the United States. Now, IEPA has a very important exception, or two exceptions, actually. The statute explicitly says that the president has no authority to regulate or prohibit, directly or indirectly, any personal communication and any import or export of any informational material. And that has become critical to the debate around WeChat and TikTok. Now, the second statute at issue here is the Defense Production Act. This dates back to 1988, when actually the concern was with Japan, and the concern with that Japan was a rising economic power and was investing in United States production capability, including production capability related to military items. And the logical concern was that you didn't want to have a foreign investor owning the only plant in the United States that makes tanks, or you didn't want to have a foreign company investing in some other military or other technology or production related to the national security. And it allowed the president again to block any acquisition, merger, or takeover of any domestic company by any foreign entity. Now, in 2018, this legislation, this Defense Production Act, was substantially amended to regulate investment generally, including non-controlling interests in US companies by foreign investors. It codified a process that had already been in place to some extent, but gave it more teeth, the so-called Committee on Foreign Investment in the United States. So people may have heard of CFIUS, and CFIUS is an interagency body within the federal government, primarily dominated by the FBI and the intelligence agencies, which conducts investigations of pending mergers, reviews of pending investments, or can go back even retroactively and undo deals that have already been consummated. And its power now, as amended in 2018, extends to any US business. And US business can include a company not registered in the United States, not incorporated in the United States, not headquartered in the United States, but doing business in the United States. And therefore, it can include, the government is claiming it does in the WeChat case, in the TikTok case, a Chinese company's acquisition of another Chinese company, that is the ByteDance acquisition of Musical.ly, which was the forerunner of TikTok, which was operating and is operating in the United States. The first two orders that you mentioned, Siegel, the August 6th orders, were issued under IEPA. The president issued a subsequent order against Wechat in also in August 14th, under the CFIUS process. So far, I think that one has not been challenged in court. That's the one that is now leading to this discussion with Oracle and Walmart over acquisition of the TikTok domestic operations. So I'll leave it there, Siegel, at least in terms of the statutory framework, and we can circle back and get deeper into some of the questions around past applications of these statutes and so on.
Thank you very much, James. That was an excellent introduction of all the legal frameworks that we started with. Thank you for doing that. And now let's take a deep dive into some of the more sophisticated legal arguments that we heard in all these litigation. So Dean Chemerinsky, now we're coming to you for the guidance as to the understanding of the constitutional arguments. Among all the litigations that were filed challenging the constitutionality of the executive orders, it seems that one of the leading argument is the First Amendment. So can you explain to us, especially to some non-lawyers here joining us today, how does First Amendment play a role in this discussion? And also when it comes to government's regulation speech, what are those different scrutiny standards and how that apply in these cases? Please, Erwin.
I'm delighted to do this and honored to be a part of this panel. What the president's executive order does is shut down media of communication. Although presidents have broad authority with regard to regulating international trade, no president in history has ever tried to use this authority or any other power to shut down a medium of communication. This, I believe, clearly violates the First Amendment. TikTok had 100 million downloads. Wechat has 3.3 million subscribers. They use it to communicate and to receive speech. And such restrictions by the government on expression violate the First Amendment. So far, the federal district courts to rule have come to this conclusion. What I want to try to do in a few minutes is explain why it violates the First Amendment. And there's three reasons, though they're somewhat interrelated. First, this constitutes what's called a prior restraint on speech. It's long been said that above all, what the First Amendment prohibits is prior restraints on speech. Blackstone did famous commentaries on English law, and his idea was that freedom of speech means no prior restraints. Well, what's a prior restraint? It's a government action that stops speech before it occurs. So, for example, if a court were to issue an injunction stopping a news story from being published, it would be a prior restraint. The most famous example in the United States involved the New York Times and the Pentagon Papers back in 1971. The New York Times and other newspapers wanted to publish the Pentagon Papers, History of America's Involvement in the Vietnam War. And the federal government went to court to get an injunction to stop the New York Times from doing so. The Supreme Court ruled against the government and in favor of the New York Times. The court said this would stop the newspaper from coming out at all with the story. That's a prior restraint. And the government has to meet a very heavy burden if it's going to have a prior restraint. The government's going to have to show there's a compelling need for its action and there's no other way to achieve it. In fact, some of the justices took the position that prior restraints are per se unconstitutional under the First Amendment. Of course, a court order isn't the only form of a prior restraint. Imagine that there's newspapers on the street and the government would go and collect every copy so no one could have it. That's a prior restraint too, and would be unconstitutional. Courts have found licensing systems where people need a permit for speech to be unconstitutional prior restraints, except when there's a very important interest and no other way to achieve it. Well, there is no doubt that President Trump's executive order are prior restraints. They are shutting down TikTok and Wechat. And in fact, I submitted a declaration in the litigation indicating that on this basis, it's a violation of the First Amendment. There is no compelling interest here. There's no showing that this is necessary for national security. There's no showing there's not other ways to achieve the government's goal. But there's a second reason why this violates the First Amendment. It restricts the ability of people to speak and to receive information. Ultimately, TikTok and Wechat are ways in which people transmit information to others, but they're also a way in which people receive information. That the First Amendment of the Constitution protects not only a right to speak, but a right to listen, a right to receive information. Now, in constitutional law, a distinction is drawn based on whether it's content-based or content-neutral. And in this sense, this is a content-neutral regulation because it applies to whatever the content is over Wechat or over TikTok. And a content-neutral regulation of speech is allowed only if the government has an important interest and only if the means are narrowly tailored. So when I say content-neutral, I simply mean the government is shutting down TikTok and Wechat, whether the speech on it is political or entertainment, whether it's pro-Trump or anti-Trump. But even something that's content-neutral, it has to meet the standard. There has to be an important interest. The government's means have to be narrowly tailored. There is no important interest here. The means aren't narrowly tailored. Also, the government can't discriminate among speakers. The government can't say, well, these speakers are favored and they'll be allowed to go forward, but these speakers aren't. In a very famous case involving First Amendment law, Citizens United versus Federal Election Commission, the Supreme Court declared unconstitutional a limit on the ability of corporations to spend money in election campaigns. The Supreme Court stressed that this is based on the speaker, corporations being disfavored compared to other speakers. I think that the effect of the ban on TikTok and Wechat is very much speaker-based. And so the bottom line is, when you think about the restrictions on TikTok and Wechat, it's limiting the ability of people to communicate to others. It's the ability of people to receive messages, and that has to meet First Amendment scrutiny, and the government can't do so. But there's a third point that I'd like to make also. The Supreme Court has said that any restrictions, speech over internet and social media, have to meet the most exacting levels of constitutional scrutiny. There's a Supreme Court case just a few years ago, Packingham versus North Carolina. And at first, it might not seem relevant to this, but I want to show you is very pertinent. What was involved here was the state of North Carolina said that if somebody has been convicted of certain crimes, here crimes involving sexual activities with children, molestation of children, the person as a condition of probation cannot be on any social media. The person can't go on the internet to look at WebMD for medical things, can't go on NewYorkTimes.com, can't go on the internet or social media at all. And the Supreme Court unanimously declared this. And Justice Kennedy's opinion talked at length about why social media and internet are so important in terms of communication. He described the number of people who are in the world on Facebook, which is greater than the population of North America and South America combined. He talked about how truly the internet, social media are the marketplace of ideas in our modern world. This follows a Supreme Court decision from over 20 years ago, Reno versus ACLU. This involved a federal law that made it a crime to have obscene or indecent speech on the internet. And the Supreme Court declared this unconstitutional. Once more, the court said that the internet is a special medium for communication, and any restrictions on speech over the internet have to meet the most exacting constitutional scrutiny. Well, there aren't many Supreme Court cases that have dealt with speech, things like social media, like TikTok, or internet, social media type things like WeChat. But these cases could not be clearer that the government should not be able to restrict these media unless the government has an interest of the highest order, and there's no other way to achieve it. As I've suggested, as Jim Dempsey suggested, the government can't meet that test, that level of scrutiny to justify this. So, for many different doctrines under the First Amendment, the prohibition of prior restraints, the unconstitutionality of limits on restricting people in their speech or receiving information, the special protection for the internet and social media, I think it's clear that President Trump's executive order violates the First Amendment. What everybody has to realize is this is different than the president creating tariff barriers, or this is different than the president saying a particular product can't enter the United States. Entirely about restricting media for communication, and it's hard to imagine a clearer violation of the First Amendment than that.
Thank you very much, Dr. D. Chemerinsky. I have to say that I'm not expert on constitution law, but you have done such a wonderful, beautiful job in describing those very complicated concepts for those of us, who are not con law experts to follow, to understand. Thank you for doing that. That's really beautiful. So, Dr. Shirk, I am coming to you. And this question is related to the timing of the executive orders. Well, as we have just heard that WeChat, that is a public forum that has been used by millions of Chinese American community in the United States, have been around for probably over 20 years. Likewise, TikTok has also been around for over probably 2 years. So why does the Trump administration suddenly decide to ban these two media apps? I mean, what has changed in the past few months that suddenly make these two media apps a threat to the national security? Please.
Well, thanks very much, Seagull, and thanks for the opportunity to join the great legal experts in discussing this important question. The Trump administration's actions against TikTok and WeChat come as really part and parcel of an administration hostile, confrontational approach to China, which has been, oh dear. Oh, sorry about that. The hostile tone of U.S.-China relations has only gotten worse with the advent of COVID. But I don't think the timing of this action is directly related to COVID. It really reflects the growing Cold War between the United States and China. And, in the US-Soviet Cold War, we had these proxy wars over client states between the United States and the Soviet Union. But as journalist Tom Mitchell pointed out recently, what we have now in the relationship between the US and China is proxy wars over corporations. And of course, Huawei is the most prominent one, ZTE, and now we see these social media companies. The Trump administration has taken a confrontational approach to China over the past 4 years, really, and it's all of government. It's quite well coordinated, but the objectives are not very clear. They haven't identified any key disputes. They certainly haven't tried to negotiate the key disputes. It's more a just pushback on every continent, every domain. And frankly, it hasn't been very effective. Really, if you step back and look, we haven't achieved any improvements in Chinese policies to be more in line with our own interests and values. And we lost the opportunity to cooperate on the pandemic, which of course has meant greater loss of life in the two countries as well as the rest of the world. So let me just make a few observations about this particular case, however. Both WeChat and TikTok are Chinese homegrown innovations. No one is claiming that the technology was absorbed or stolen from abroad. Both of them really are in the vanguard of social media internationally. These are private companies. Of course, they do depend on the patronage of the government, as all private companies in China do. Another observation I would make is there really was no upsurge of American popular demand for these moves. American young people love TikTok. Chinese Americans and people like me who are professionally involved with China, we rely on WeChat to communicate with family, friends, and colleagues in China. People know that it's censored, but they exercise care and try to keep away from political speech. Another observation that really surprised me is that the administration didn't seem to have anticipated that the Chinese government would retaliate. It seems so obvious now. They have established what they call an unreliable entity list. They haven't yet identified American firms that would go on the list. I think they're waiting to see what happens during the next few weeks, but they have given themselves the authority to ban or otherwise sanction American companies, and they have instituted export controls against transfers of technology like TikTok's algorithms. So what that means is that ByteDance will require a license to allow the TikTok sale. I can envision the possibility that Beijing would kill the deal, tell ByteDance that they can't allow TikTok to be transferred even to some kind of partnership with Oracle or another American firm, and what they will call it is attempted intellectual property theft. They'll say the American government is using state power to expropriate the intellectual property, China's intellectual property. And they could even go so far as to ban Apple or Qualcomm from China. Another result of this quite extreme action is that it's law, especially as part of a general Trump administration approach to confront China across the board, is that it's lost America a lot of respect in China. Even those people who used to admire the US model now are feeling alienated from the United States. They accuse us of hypocrisy because they say, well, you talk about the rules-based international order, but you've abdicated from it. You talk about an open market economy, but now you're acting just like China to violate private property rights, to restrict foreign businesses and favor domestic ones. So now, in conclusion, I just want to emphasize that, of course, the Chinese government did bring a lot of these problems on themselves. They started overreaching even before the Xi Jinping era in the mid-2000s. They were the ones, of course, who banned Facebook, banned Google, YouTube, Twitter, and other social media. They have behaved quite aggressively in the South China Sea. Domestically, of course, they've ramped up censorship, surveillance, gradual reforms, political reforms, and economic reforms really have ground to a halt, and the party has tightened control over media, internet, and civil society. So, and under Xi Jinping, even though this started in the Hu Jintao era, it's become even more conspicuous and more offensive to Americans and to people in other countries under Xi Jinping. And, I won't give a long chapter and verse about the Hong Kong security law and surveillance and re-education camps in Xinjiang. But I think it's important to point out that the backlash against China is not limited to the Trump administration. It's bipartisan in America, and it goes beyond America to countries in Europe, Australia, and many other countries around the world. So the interesting question, of course, is whether or not, if we have a new administration, will this provide the opportunity for a reset? And if the Biden administration is more practical, more willing to set priorities and negotiate in a spirit of goodwill to provide some off-ramps from the current hostility, will Xi Jinping have the confidence to walk through that open door to stabilize relations? Will he be able to make some compromises in order to take advantage of this new opening to stabilize relations? So a lot of this in the end will come down to Xi Jinping, his leadership, and whether or not he still has the pragmatic gene that previous Chinese leaders once had to exercise restraint, make compromises in order to maintain good relations with the United States and with other countries. Thank you.
Thanks, Susan. Apparently, there's lots of uncertainty moving forward from both China and the United States. But one comment that I find it very interesting was you mentioned about that, both TikTok and WeChat are really China homegrown technologies and media apps that really depend on most of them, or probably 100% of the Chinese IP. So it was very interesting, comment to say, well, this might be perceived by Chinese as American using the state power to try to take Chinese IP. Because I am an IP lawyer, so that seems to me is very, very interesting comment. And we'll come back to some of the comments later. One thing that I have to admit was when I agreed to be the moderator of today's webinar, we all realize that we're really trying to grasp some very not only important, but big and vastly different subjects from one area to another area. So we're trying to talk about constitutional law, we're trying to talk about cybersecurity and data privacy, and we're trying to talk about international relationship. We understand that each of them probably deserve a few hours of attention by its own. So that's a task we're trying to jump. Now we're coming back to you, Jim, back to the subject of national security and cybersecurity. So we understand that the executive orders were issued based on the national security risks. And can you comment on that? Based on the current evidence that we have seen or that has been presented by the DOJ, what are the specific risks that have been identified by the Trump administration, and how real, how valid are those risks?
Well, you know, I think you do have to view, there are multiple different ways, of course, to view and multiple different perspectives from which to view these two bans. And Susan gave some of them in terms of the broader context of US-China relations. There has been this multi-year growing level of concern about Chinese products and services in the US telecommunications ecosystem. It goes back before the Trump administration. A lot of it focused on concerns around Huawei and the Huawei equipment that's in the, or was potentially going to be in the backbone of the US telecommunications infrastructure. And even before Trump, there were moves to remove that. And largely now, I think that Huawei and ZTE equipment is removed from the US networks. We've seen simultaneously a growing concern, and to some extent ratified by Congress in 2018, with data. So the concern had begun with hardware. More recently, the concern has shifted over to data. And that's really the focus in many ways of both the TikTok and the Wechat orders. Now, in the case of TikTok, the president's executive order specifically noted the kinds of information and the variety and volume of information that the TikTok app collects and reports back to TikTok, reports back to ByteDance, the wide range of information. Now, one thing to recognize is the information that is collected by the TikTok app is collected by almost every single app on your phone. So this is, in a way, standard data collection by an app. When you install the app, particularly if you're not careful with the permissions and how you set the permissions on the app, it will collect your location. It will collect your address book information, the names and telephone numbers and other identifying information on all of your friends. It will, of course, record your interests. It will collect what videos you are looking at. And all of this gets reported back to the owner of TikTok, in this case, the company ByteDance. Now, ByteDance says that data is stored outside of China and is not available to China. The Chinese government has never yet asked for it. And the company says that they would resist any effort to obtain it. No doubt the Chinese government, and probably other governments as well, including potentially even the US government, are interested in this kind of social graph data. Who knows whom, who's connected to whom, who communicates with whom, when, where, what their interests are. So, you know, in a way, we're talking about one of the byproducts of the design of the internet economy, one of the byproducts of the design of the app-based, you know, economy that is all of us have here, where this information is acquired. The US government is concerned that China then could demand the data and that the TikTok leadership at ByteDance would be unable to resist that. The government has also argued that TikTok reportedly, and it's interesting that the president's executive order says reportedly censors content, content that might be of embarrassment to the Chinese government, not the US government. And there's a concern that the TikTok app may, and again, the executive order uses the word may be used for disinformation campaigns that benefit the Chinese Communist Party. The Wechat situation is different. So Wechat is, of course, owned by Tencent. It is a Chinese-based product. It is a product that people use for communications, text, voice, video, social media, sharing, photographs and other material, and electronic payments. And I think that one has to assume, I certainly assume as a user of Wechat myself, that whatever I do and say on that is not private, at least not private from the Chinese government, that it's potentially available, that a lot of it, certainly when you're in China, it's readily accessible to the Chinese government. So I draw a little distinction between TikTok, where I think there's the potential, but so far, at least I haven't seen any evidence of the reality of Chinese government exploitation of that huge amount of data. And certainly TikTok's quite adamant statements that it has never been demanded by the Chinese government, versus Wechat, which I think you have to assume is like any other China-based communication service, that it's highly vulnerable in that regard. And I assume that all the users of Wechat understand that and accept it as sort of the price of doing business in terms of the capabilities of the service. Now, one thing that's interesting here, again, is this growing interest in data. Using the authorities under the Defense Production Act and this CFIUS process, Committee on Foreign Investment in the United States, the Trump administration has become very aggressive in blocking a wide range of transactions or forcing the unraveling of a wide range of transactions. So last year, the CFIUS process forced the Chinese company Beijing Kunlun Tech to divest itself of a gay dating app called Grindr, which Kunlun had purchased in 2018. CFIUS in 2019 forced Chinese investors to sell another US company, Patients Like Me, which collected medical data. The CFIUS process blocked Ant Financial, major Chinese company, from acquiring MoneyGram International. So this focus around data has become a major concern, certainly as a generic concern. Nobody can say that it's unjustified. Nobody can say that data does not have strategic value or intelligence value or national security value. It clearly does. Whether in the case of TikTok or in the case of Wechat, the president has made his case is a little bit uncertain. I certainly see that I think the president made, and Congress, members of Congress through their investigations and reports have made, I think, a much stronger case, for example, with Huawei, where the concern was that switches and other hardware at the core of the US telecommunications infrastructure were subject to degradation or interception or other mischief through software upgrades or otherwise, and that was, I think, genuinely a cause for concern. I see WeChat as different from TikTok. Now, what's also interesting is the First Amendment issues that Dean Chemerinsky brought up are quite powerful, even in the case of national security concerns, where there's a communication, a personal communication at issue, or a public square, which is what the court said that WeChat was. So even with a strong case, the president may run into trouble both on the text of IEPA, which prohibits directly or indirectly prohibiting communications, and on the First Amendment grounds. But it's clear to me that the concern over Chinese products in the American sort of internet and telecommunications infrastructure, I think it's here to stay. I think it was bipartisan on the part of Congress. I think that you're looking across a wide range of issues: hardware, software, companies, apps, and that this is going to remain, I think, an area of concern, at least. Whether TikTok or WeChat were the right next targets for the administration, I think is a little bit open to question. And again, I draw a distinction between the two of them. I'm not sure TikTok was the right one to go for next.
Thank you very much, Jim. One thing that I like very much was you made an effort trying to distinguish TikTok and WeChat. I mean, we basically loop these two together for this one whole webinar, but we do understand these two apps. I mean, the similarities probably here, what is at issue is that they're both owned by Chinese, but they do have different consumers, different technology, different functions, and therefore probably different risks involved. So thank you for separating them out and also explaining to us what are the specific risks associated with each of those apps. Now, we are moving into a more robust discussion now, and I will start with Dean Chemerinsky. You just did talk about the First Amendment. So one thing that I also noticed was the Fifth Amendment seems to be also relevant to the discussion, especially when it comes to the Equal Protection Clause and also the due process. Can you just quickly elaborate on that point, please? Irwin, you're muted.
I say yes. This issue has been litigated in some of these cases. It's both in the sense that there is a property interest involved, but also a liberty interest, speech. And is the government taking away this property, this liberty, without providing some form of due process of law? With regard to equal protection, the Supreme Court has long held that the Fifth Amendment also says that the federal government cannot deny equal protection laws. Equal protection requires, excuse me, that like people be treated alike and unlike people be treated unalike. And the argument here is that the federal government is treating these media differently from other media in a way that's discriminatory. Frankly, though, I find both the due process argument and equal protection argument to be derivative of the First Amendment speech argument. If this doesn't violate the First Amendment because there's a compelling no other way to achieve it, then it's not going to violate equal protection either. And with regard to due process, not sure how much would be required if there's a compelling government interest. Maybe more procedures than this, but if the government can convince the court that it has such an overriding interest and no other way to achieve it, I think that then the due process and equal protection arguments are less likely to succeed. On the other hand, if the challenge under the First Amendment works, then due process and equal protection become unimportant. So the arguments are there. Lawyers always like to present alternative arguments so they can cover their bases and have many opportunities. But I don't think that these are as strong as the First Amendment arguments.
Thank you very much, Irvin. Especially I like the conclusion you had. As lawyers, we never just to prepare one strike. It's always 5, 6, 10 strikes as backup strategy. So for those who are legal professionals joining us today, that's a great piece of advice from the Dean of Berkeley School of Law. Now let's come to Dr. Shirk. You just did talk about a very, very interesting question, proxy, in describing the TikTok WeChat story. Well, actually, that is something also we noticed that in both the executive orders and also the following responses motions filed by the DOJ, it seemed that really the nationality of the two apps, or in other words, the country of origin where they come from, seems to be the determining factor as to the entire picture analysis. And it just happened to me that I read a very interesting article in one of the September issue of The Economist, which also had a quite interesting discussion on the WeChat TikTok ban in terms of globalization. So it was noted that one of the general understanding, or at least expectations, since one of the most modern globalization started in the 1980s, has been that, well, all global firms should be treated or would be treated equally, regardless of their nationality. Well, let's put aside those most favored nation clause and those international trade agreements aside for just 1 minute. But in contrast to this general expectation, back in the 1930s and 40s, during the war period, global business actually had to respond by structuring their management teams, capital structure, and production system quite differently in response to the wars and the nationalism. For example, at the time, General Motors had to restructure their foreign operations quite semi-independently. So in your opinion, the current bans against TikTok and WeChat, does that suggest a new trend that we are moving away from globalization that started in the 1980s for the recent move, but more into direction of 1930s where protectionism and local and nationalism was around? And therefore, was that something that global business had to take into consideration moving forward? So as to respond differently? Susan, you're muted.
I'm afraid, Seagull, that you're right. I think that is the trend that we see underway. And it's really quite tragic and it really has shown us how intertwined the US and the Chinese economies, our technologies, our innovation ecosystems, our societies, our higher education, everything is so intertwined now. And to try to break that, to unravel it, which is a lot of what the Trump administration has been trying to do. And now the Chinese government is responding by, once again, pursuing self-reliance in technology. They feel that they have a lot at risk, and so they have to try to go it alone, certainly on advanced semiconductors as well as other things. So, and I think that the nature of the Chinese system of social control and party rule has really made it very, very difficult for many Chinese firms to operate internationally. You look at Chinese FDI in the United States and other countries, went way up peaked in 2017 and has just really crashed since then. The problem is the regulations, CFIUS and CFIUS-like procedures in European countries as well. But there's just, as Jim Dempsey said, especially now control of data, it will be pretty well impossible for any Chinese company to demonstrate that they don't have control of data, because so many businesses, not just social media ones, are really information businesses as well as their other primary activity. So what this means is that they will no longer be welcomed or trusted in the United States or in many other countries. But of course, it also means that our companies are going to face a lot of the same obstacles, certainly in China and potentially in other countries as well.
I think I heard similar arguments in other forums where it was said that, well, the United States, well, actually is not welcome in certain other countries' world. So this might be a very bad precedent, so the other countries who don't necessarily like America might just retaliate the same, targeting American-owned companies. I
just want to note that, recently I read that not only has Chinese FDI in the United States declined precipitously, but all foreign direct investment in the United States has declined, because countries are worried about the political risk they might face in investing in the United States if the United States is carrying out hostile relations with China or even with other countries. They don't want to get trapped in that situation.
And that probably also explains why we have registrations, people calling from 29 countries joining us webinar today. This is partly just beyond the US-China issue, but it sends a very, very interesting or even dangerous important message to all of the world. So we are almost running out of time. Let me quickly go to the questions to see if some questions from our audiences. One of the questions is to you, Jim. It is about misinformation and disinformation that has been, very often found to be related with social media sites. So with the presidential election approaching within 30 days and the president's current health conditions, what would you recommend that can be done to minimize the misinformation risk or disinformation risks that for all the social media apps to follow moving forward? Is there a best practice here, Europe, or something that we should think about, draft, so as to for all of the social media apps to follow?
Well, at this point, we're seriously behind the curve on that issue. The various social media platforms, the least of which in this case is TikTok, are flooded with a wide range of misinformation or disinformation. And a lot of that is not foreign controlled or directed. The Russians presumably are active. China apparently less so currently, at least that's my reading of the material from the that's been published by the government. But the Russians and Chinese aside, we've got plenty of it domestically. And, I really think that certainly the companies have fallen down on it. They've made efforts to control it, but not enough, too little, too late. Still, I think trying to hold on to their business model, which is based upon, grabbing our attention and holding it for as long as possible. And a lot of this stuff does grab people's attention and hold it. I really think that the response in this case for now, at least for the next 30 days, and whatever is the vote counting period after 30 days, so let's say for the next 2 months, basically anybody who's in politics has to be saying, there's a lot of misinformation out there. You have to anticipate that people are going to be declaring the election over before it's over, that people are going to be arguing for stopping counting the votes, that people are going to be promoting all kinds of misinformation about voter fraud, about polls being opened or closed, and tied in with some of the voter suppression efforts that have been, unfortunately, part of our political process now for decades. So I really think at this point here, yes, that the political parties, and I sort of feel that the Democrats have been on the receiving end of more of this than the Republicans have, but the political parties need to be continuing to hammer away at the companies to increase their content moderation and their takedowns and their vigilance on all kinds of information and disinformation, voter misinformation, et cetera. But I also think that the political parties have to be out there saying, look, people are going to try to manipulate you, and you need to be prepared for it, and you need to start increasing your personal diligence and your personal ability to tell fact from fiction, because it's going to be a crazy 2 months. It is just going to be an insane 2 months. You just have to figure that. And if we don't have an answer, and we very likely won't have an answer on November 3rd, it's just going to be crazy with stuff floating around. And so I think, if you're running a political campaign now, you basically have to anticipate that and start working to self-inoculate yourself and prepare for the worst.
And Jim, speaking of the crazy next 2 months, I would have to say, we had an extraordinary 2020 anyway. So we probably are ready to face anything at this.
Yeah, well, it's, this year has already lasted about 25 years already. And we got another 5 or 10 years to go before we're finished with this one.
We have all become very strong and resilient. But, I was just personally hoping that the next 2 months will be relatively more peacefully. So, Irwin,
the bottom line, Siegel, is that the disinformation issue, we've got our own homegrown problem with disinformation.
And probably media could also play a role in trying to clarify some of the misinformation, moving forward. And all of us, could probably take some of the responsibility in clarifying some of the issue versus just to rely on everything that you read over the internet, right? So Irwin, I'm afraid that I have to put you on the spotlight now. So I have a question for you. It seems that is a question in the minds of lots of our audiences. The question is, what is your view? What is your prediction as to the outcome of the executive orders and also as well as litigation? I mean, assuming that you can read a crystal ball and taking into consideration that the uncertainty surrounding the presidential election within the few months, until January 2020s, and also the Supreme Court Justice confirmation.
I start with certainly this Supreme Court inclination is to defer to the President of the United States. We saw that with regard to the Muslim travel ban, where President Trump issued the executive order and ultimately the Supreme Court sided with him, what I think was a misguided and tragic decision. And generally, Supreme Courts side with presidents when it comes to matters involving foreign relations. Even having all of that in mind, I think that here the courts are going to rule against President Trump on First Amendment grounds. And that's what the district courts have done so far. And I think they're right. I'll back to where I began. Never before has a president tried to ban a medium of communication. And that's what he's done both with regard to TikTok and WeChat. Imagine a president were just to try to stop the sale of a single newspaper in the United States. The president were to say, I regard this newspaper as propaganda. I'm going to ban the newspaper. Everyone would agree a ban of a newspaper would violate the First Amendment. This is so much more than that in banning all of the communication over TikTok and over WeChat. So even given a court that's disposed to ruling with the president, even given a history of Supreme Court deference in matters of foreign policy, I don't see the court splitting would uphold this. I think it clearly violates the First Amendment.
Well, I have to tell you that personally, I really love your answer because I do use WeChat a lot. And I sent red envelopes to my parents living in China. I pay their water bills depending on that. So that's really what I personally like to hear. And that's the last question that I'm going to direct to Dr. Shirk. That is a question also that I heard a lot, and again today on the Q question here, that's about reciprocity. So the question is that we understand, and you just talk about that, a lot of US-owned social media apps have been denied access in China. So one question is that, and therefore, is that a fair question to say that, does it justify for the US to also ban, the China-owned apps from the US market? And a follow-up question to that is that a right strategy? Is that a wise strategy? Or is there anything else that we could do? Because you just talk about, it seems that the current administration has not done an excellent job negotiating seriously with China. What is your response to that?
Well, I believe that our approach has to be a mixture of doubling down on all the strengths of America, which have to do with our openness, with our free market, with our welcoming of immigrants and students to our great universities from all over the world. And that, we shouldn't get involved in just a reciprocity game, because we don't want to be just like China. We want to be a better version of ourselves. But in some areas, I think that it does make sense to have a kind of negotiated demand for reciprocity, negotiated reciprocity. What we're seeing here is not actually some kind of diplomatic negotiation in which we, go to the Chinese government, say that we think this is really unfair. It puts us in a very different position, American companies and Chinese companies. We're open, you're making only allowing firms that you believe are friendly to China or that you can control into the China market. So there's a kind of negotiated reciprocity that in some areas I think we should definitely be employing. And that would have been another way to go here. Not just to use these very draconian executive orders, but let's start with a negotiation. Identify the unfairness of the situation and see if there is some way that we can somehow resolve that. That will take pressure on our side. I'm not saying that we shouldn't threaten to employ sanctions. Sometimes that will be needed, but I'm not naive that, we'll just sit down and hold hands and solve all our problems through negotiation. But this administration never even tried to talk to the Chinese side. So I don't believe that really it's been tested whether or not you might have been able to negotiate some greater reciprocity in this area. But, on the other hand, this is very political, very sensitive. the Chinese party leadership wants to be able to control access to information in China. And we're never going to be like that. We don't want to be like that.
Thank you very much, Susan. Again, apparently we are running out of time. On behalf of the audience, let me sincerely express my gratitude to the outstanding speakers today who have shared their time and insight and knowledge with us. Erwin, Susan, and Jim, thank you very much. I have so much to say, and I see there are 42 questions in the chat box. I don't think we're going to finish them or go to even most of them today, but this will be a very good start for the continuing conversation, negotiation, and a possible collaboration for governments, hopefully next year. And I absolutely love the comments that there are lots of areas that we really should collaborate, and we should have collaborate at least on the COVID-19 and probably moving forward in the climate change. I mean, there's lots of meaningful areas where we can put aside differences and try to work together, either through meaningful cooperation, negotiation, or whatever other channels that we try to explore. So let me just conclude on that. And I'm turning the microphone to Angelia, our Associate Director, for some logistic announcements and whatever news she has to say. Thank you again.
Thank you, Erwin, Jim, Susan, and Siegel, for that very insightful discussion. I would like to take this opportunity to express our gratitude to Himalaya Capital for sponsoring this program. There are also a number of partners we would like to thank for their promotional support. These include the 21st Century China Center at UC San Diego School of Global Policy and Strategy, AmCham Shanghai, American Business League of Southern California, Berkeley Center for Law and Technology, Japan America Society, Los Angeles World Affairs Council and Town Hall, UCI Long U.S. China Institute, UCLA Luskin School of Public Affairs, USC Gould School of Law, USC Marshall School of Business IBER MBA Program, USC U.S. China Institute. If you enjoyed tonight's program, please consider showing your support by making a donation or becoming a member. To donate, please visit asiasociety.org/donatela. To join, please visit asiasociety.org/memberla. We would greatly appreciate it. Lastly, please mark your calendars for our next program, Money Games, the inside story of how American dealmakers saved Korea's most iconic bank, with Wei-Jing Shan on October the 13th at 5:30 p.m. Pacific. Thank you and good night.